This is chapter 13, Dismissal with Cause. So in chapter 12, we discussed the end of the employment relationship by way of either retirement or resignation. So when the employee voluntarily asks to leave the employment relationship. Today we'll be discussing about the employer's right to dismiss an employee with cause or with just cause. So in other words, when the employee acts wrongfully or breaches the employment agreement. So we'll be looking into more details as per the differentiation of a good reason for dismissal and the just cause for dismissal under common law. We'll also be looking at explaining the contextual approach in order to determine just cause for dismissal. We'll be discussing specific grounds for just cause. For instance, dishonesty, insolence, drunkenness, disobedience, etc. And we'll also be looking at some related concepts such as condonation. So let's first start with an overview of just cause. So actually an employer can either have a just cause for dismissal, and that just cause is created or arises from the misconduct of the employee, or absent just cause, the employer may provide reasonable notice or pay in lieu of notice and dismiss an employee. So remember, in a private relationship, contractual relationship, employment relationship, the employee has no job security. So the employer can dismiss the employee if the employer doesn't want the employee anymore, as long as they provide reasonable notice or paying in lieu of the notice. In specific cases, under exceptions, the employer may dismiss for just cause. And this is those are the grounds we'll be looking at in this chapter. So just cause does not mean that the employer has a good reason to terminate an employee, but actually it means that the employee breached the employment contract in a fundamental way, in a substantial way, in a way that the employer is no longer bound by the agreement. So it is the employee acting wrongfully in a way that breaches the agreement. But this breach has to be in a fundamental way, in a substantial way. It cannot be a minor breach. Okay? But we'll look at several examples throughout this chapter, and this fundamental way will be clear to you. It is usually a difficult standard to meet, and whether there was just cause or a valid just cause or not is usually decided on a case-by-case basis. So it is not uncommon for employees who were dismissed for just cause to sue for wrongful dismissal, and then the court will give the final word in a way to determine there was indeed just cause, because the contract of employment was breached in a fundamental way or there was not. What was allegedly referred to as just cause by the employer could not be regarded as just cause. Then, in this event, the employee would be awarded the amount as per the reasonable notice they were entitled. Who has the burden of proof or onus of proof? So the onus of proof is on the employer. It is the employer that has to have records, that has to establish the employee breached the employment agreement in a fundamental way. And you may remember chapter 1 or 2 where we discussed balance of probabilities. So this is how cases are proved in court. Civil cases and employment relationship fit into a civil case. They are decided on a balance of probabilities. In other words, it means based on the evidence brought in court, the judge will decide in favor of one of the parties. Balance of probabilities does not mean certainty, does not mean 100% sure. No, it means that chances are higher that X happened instead of Y. So based on the evidence brought to court, on the proof made in court, the judge decides on what is called balance of probabilities. This is different for criminal cases. And why is it needed to mention here criminal cases? Because if the employer dismisses an employee allegedly for a criminal conduct, the standard of proof here is higher. So in criminal cases, the prosecutor has the onus, the burden to prove beyond any reasonable doubt. If there's any doubt the accused committed the criminal conduct, the accused has to be acquitted. And a similar concept applies here for an employer who still is in doubt whether the employee committed or acted wrongfully in a criminal nature. So whenever an employer wants to dismiss someone for just cause based on a criminal offense, they have to remember and bear in mind that their evidence has to be clear, straightforward, and very convincing, because the burden of proof here is higher, the standard of proof is higher than the balance of probabilities. Usually there will be witnesses, video recording, voice recording, proving that the criminal conduct took place. Okay? Dismissing someone for just cause, an employee for just cause, is also known as all or nothing. All or nothing meaning that, so if you dismiss someone for just cause, and you were sued for that, you were sued for wrongful dismissal, you will either win or lose. You will either have the just cause confirmed, or if not confirmed, you will have to pay the amount for the reasonable notice. So there isn't like a midterm, a middle way here. It's either all or nothing. So as an employer, you should make sure, because the onus of proof is on you, you have to make sure you have met the requirements for just cause. And throughout this chapter, we'll see several grounds for just cause, but we will be also referring to several case law and several understanding from courts that serve as a guide for employers to dismiss in a valid way for just cause. Proportionality and contextual approach. So those are two important concepts for just cause. Well, employees, they may act wrongfully, they may make a mistake, they may be involved in misconduct. However, the sanction to be applied by the employer must be proportional to that misconduct, to that wrongful conduct. So, and how can employers be proportional? Well, first of all, they will look at the overall employment relationship. They will also look at the performance records or the sanction records if it was a first time incident or if the employee has committed that second way, third way. So this is looking at the overall employment relationship and also proportional. Well, um, the more serious the conduct is, then the more strict or the stricter a sanction may be. Okay, so this is being proportional. In some exceptional circumstances where there's a serious criminal offense, such as a theft or serious sexual assault, for example, this one-time incident could justify summary just cause dismissal. Okay, but remember, because they are criminal offenses, even though they are serious, remember, as an employer, you have to have clear, convincing records or proof or evidence of that incident, that conduct. And if they are not so serious misconduct or performance related issues, they usually have to occur more than once. And as we discussed before, progressive disciplining has to be followed here. So, like absenteeism or incompetence. So, most issues that are not so serious in principle, they must occur more than once, and the employee may have received um, warnings 2, 3, or more. So the contextual approach is related to proportionality because while approaching an employee to sanction or to dismiss for just cause, the employer has to take into consideration the nature of the misconduct, how serious it was, and again, looking at the overall employment relationship. In other words, if the employee has been working for the company for 5 years, 10 years, and it was the first time such an incident happened, then um, it's more likely that the employer should give a warning or apply any other sanction, but not just cause dismissal. So the contextual approach is very relevant, and we'll look at some cases as we move forward in this chapter. So two important concepts. Again, being proportional while applying sanctions, but also taking into consideration the contextual approach, the overall employment relationship. And procedural fairness is also relevant. So those are legal rules. They come from natural justice, and those natural justice rules, they apply to all entities, organizations, whether they are governmental or private institutions or organizations. So in any type of procedure in which there may be a sanction, there may be a punishment, procedural fairness has to be there. If there's no procedural fairness, the affected person or the victim, in this case the employee, could bring the issue to court, and the judge would order procedural fairness in that process. So Being fair while processing that misconduct in a way to assess if any sanctions will be applied means, in other words, investigating the breach of the contract thoroughly and as soon as possible, so promptly, in good faith and in confidence, also giving the employee full opportunity to respond because there may be a reasonable explanation. So let's say the employee has been absent for more than once or twice. It may be the employee is having a hard time at home or with their family or with relatives or neighbors. So there may be a reasonable explanation. So you have to make sure you give the employee a full opportunity to respond. Or there may be extenuating circumstances. And how the employee responds to the allegations will matter. Because if they are honest, if they don't lie, but if they deny and later on you find out they lied, then this would go against them. So sanctions could be more strict here, or stricter, or more harsh. You should also consider the misconduct, whether the misconduct was planned and deliberate. Misconduct here also the breach of the employment contract. Whether the employee exhibited remorse when they were confronted, and you should also assess the misconduct in the context of the employee's previous disciplinary and performance records. In other words, taking into consideration the contextual approach here. So following those steps, you should be fine. The employer should be fine as per procedural fairness towards that alleged breach of contract. The grounds for dismissal. So, at any time, an employer who wants to dismiss an employee, they can do so without just cause. So, in this case, as we'll see in Chapter 14, the employee is entitled to a reasonable notice or paying lieu of notice. The employee may be dismissed without just cause, but in a later date, the employer may find out it actually had just cause at the time of dismissal. It is just that the employee was hiding something, or the employer did not have access to certain knowledge or certain facts. So that is possible, and then you can change the records, and you could seek the reasonable notice payment back, even though this is not common for employers to sue employees because of legal costs. The employer can also justify dismissal based on information acquired later. That's just exemplified. And if that is the case, the employer will then change the grounds for dismissal. So initially, the employee was dismissed without just cause, given reasonable notice or paying due. But then, because the employer found out later that it had just cause for dismissal, then it may change the grounds. And that may affect employment insurance, may affect other rights of the employees. There's another way, because dismissing an employee for just cause is a bit difficult, as we saw, is a standard that is not so easy to establish. So in some cases, employers, they will dismiss with just cause, but they will still provide payment as a gesture of goodwill. So in this case, you could use an expression without prejudice. So you pay the employee, but you make it clear that payment is not related to the dismissal, but it is related for the employee not to sue the employer in the future. And so you are giving consideration, you are paying a price, and the employee is agreeing not to sue you. So you could do this in the separation package, to say so. And this usually helps avoid litigation because the employee just got some money. Without prejudice will also mean that you are paying, but you are not waiving any of your rights you may have in the future, and you may decide to seek remedies for. Okay, so that is more of a legal nature, but you could use this in this gesture of goodwill. Condonation. So to condone someone. So an employer will condone an employee when the employer discovers a misconduct or poor performance and then fails to respond within a reasonable time. And reasonable time here will be subjective. So it depends on the misconduct, what the misconduct or what the poor performance is. But reasonable time could also be understood as soon as possible, or as soon it becomes practical to correct that misconduct or poor performance. So if the employee fails to respond, to correct within this reasonable time, then the employer is actually condoning that behavior. And in the future, the employer will be prevented, will be barred from responding to a similar misconduct or poor performance, whether it is related to the same employee or another employee, because the employer condoned before, and that condonation created the basis for the future. So it is very important for HR professionals to be to have their attention in misconduct, wrongdoings, poor performance, in a way that they respond, they keep the proper records, so it does not become condemnation. Okay, this is very important. So the reasonable time here is also to allow the employer to decide how they will handle the situation. But again, the employer has to respond as soon as it is possible, as soon as they find it practical to respond to that misconduct or poor performance. So some principles related to just cause. The employee must know what is expected by the employer. So in terms of their job duties, performance, policies, handbooks. So through all those aspects, the employee should be aware, should know what is expected from them. And the employee should also be advised when the employer is not satisfied of their performance, of how they are working, and the employee should also know that their job is in jeopardy. So how does this happen? This usually happens in true, genuine performance appraisals where the employer gives true, accurate, and genuine feedback, telling the employee that they are not satisfied with their performance, giving resources, opportunity for the employee to improve, to correct, and if such improvement or correction does not happen, the employer should inform the employee that their job may be in jeopardy. They may lose their job. Again, it's a kind of progressive disciplining, but also using the performance reviews, performance appraisals to be clear, to be open, transparent with the employee. If there are cumulative causes, so different types of misconduct, it may justify dismissal with just cause, without notice. If there were mere inadequacies or errors in judgment, those cannot be considered valid grounds for just cause. They may be valid grounds for warnings, for correction, for performance reviews, but not for summary just cause dismissal. There are higher standards for positions that have public trust. So those employees, they have higher standards, and they need to respond to those higher standards. If not, they may justify just cause for dismissal. Abuse of authority or willful disobedience, they may justify dismissal. The more serious the abuse of authority or the willful disobedience is, higher the chances will be that just cause dismissal will be valid. The employer can also rely on grounds that are discovered after the dismissal. So we discussed this a little ago. But those grounds, they have to be related to conduct during the employment agreement. It is not the conduct after dismissal. It is just the discovery of that conduct, of those grounds after the dismissal. Conflict of interest may justify dismissal. We'll see one case in this regard. The employer is also entitled to determine rules they want in their company, at the workplace, as long as those rules, they are not illegal, they are not dishonest, and they are not dangerous. So the employee has to follow those rules. And employees may be terminated for cause while they are on sick leave. So if the employer finds out about a cause or ground that justify just cause, even while the employee is on sick leave, the employer is allowed to terminate for just cause. So now we are going to look at the specific grounds for just cause. So we'll look at the several grounds moving forward. So the first one is dishonesty. So historically, any act of dishonesty would constitute just cause. But nowadays, the contextual approach has to be applied. So if it was the first incident or an incident that is not so serious of dishonesty, then progressive disciplining or a proportional sanction would be more correct, more valid, rather than just cause dismissal. For example, this first case we look at McKinley versus BCTL. The Supreme Court of Canada understood that dishonesty must undermine the crucial element of trust in the employment relationship to constitute just cause. So it has to go to the root of an employment relationship. An example here would be if an employee works with cash handling and then they steal some money, or they lied about something related to money, to a sale, to cash. So this would go to the very root of the employment relationship. In this case, the employee failed to disclose medical records, but then the court understood that the conduct was dishonest, but not in a fundamental way that undermined the employer-employee relationship. So in this case, even though the employee was fired, dismissed for just cause, the court understood that there was um, wrongful dismissal. In Luster versus BC Ferry, the court understood that suspicion is not enough. Actual proof is needed. So in this case, there were unjustified allegations of theft, and that would cost the employer additional compensation. So they were unjustified allegations. Again, if it is a misconduct of criminal nature, actual proof is needed. Suspicion will never be enough. Okay, remember here that the standard of proof is higher for the employer. So how should employers deal with dishonesty? Well, first of all, they should provide clear written policies. In an event of dishonest misconduct, they should get the facts right. And in case the allegations cannot be proven, but the employer still wants to dismiss the employee, then they'd better dismiss the employee without just cause, giving the notice or making a payment in lieu of the notice. So in this case, they would avoid litigation. Now let's look at insolence and insubordination. So normally a pattern, several incidents of insubordination or insolence must be shown. So normally there may be serious incidents of insubordination in which, let's say, the supervisor, the boss, the director would lose control of the people they manage. Then that could justify just cause. But usually a pattern, a sequence of insubordination must be shown. So the first case here is Motorcell versus Gulf Oil. Here the engineer had access to sensitive company information. The engineer got upset after a meeting, and the engineer made the remark that he would delete all his files and leave no tracks. So the employer interpreted this as a security threat. However, and then they dismissed the employee for just cause. But the case found that those threats, they did not justify summary dismissal, because it was a long-term employee who had an excellent performance record. So it was one incident. And so in this case, the employee was awarded compensation for wrongful dismissal. And see, again, it's not easy to establish a valid just cause for dismissal. In Henry versus Foxco, the supervisor questioned the speed of the employee's work, and in a heated exchange in front of other employees, the employee said 5 or 6 times, "If you want to fire me, go ahead and fire me." And the supervisor finally did. In this case, the court understood that the employer did not have just cause for dismissal, because this insubordination was an isolated incident. So here the employer could not establish that the supervisor was undermined in their ability to direct the workplace. And also there was no evidence that the incident damaged the employer's reputation to the public. So another example of a just cause that turned to be regarded by the courts for wrongful dismissal. So an invalid just cause. Incompatibility. So incompatibility is usually vague or too vague to be a just cause for dismissal. The employer would need to establish that the employee does not fit in or has personal habits that are not compatible with the dominant workplace culture. And here we have an interesting example. So Essery versus John Leck and Co. The employee was dismissed for just cause. The employee was a hairdresser, but had greasy hair, smoked heavily, and neglected his appearance. So the employee's personal habits harmed the employer's business. And here the court decided in favor of the employer. So the employer was sued for wrongful dismissal, but the employer had a successful defense and could establish that the employee's personal habits actually harmed the employer's business. Off-duty conduct. So if there's a misconduct outside the workplace, the employer would need to show that the misconduct harmed their business. And the example here is with Pnussen versus the University of Western Ontario. So a professor was dismissed after being convicted of an insurance fraud. So here the court understood that dishonest conduct on the part of a faculty member could harm the university's reputation. So this was a valid just cause dismissal for off-duty conduct. What if there's an off-work conduct but it is online? For example, can blogging or can social media get you fired? The answer is yes, if the conduct relates to the reputation of the employer. So if you go online and you harm the reputation of your employer, yes, this could justify just cause dismissal. So employees should be cautious about giving their opinion online or to third parties about their job. Now, conflict of interest. So employees, they have an implied duty of faithfulness or loyalty to the employer. Moonlighting is usually not allowed. In most employment contracts I've seen, having a second job is not allowed. But those are the ones I saw. If there's no such prohibition in an employment agreement, then it may be understood that it is allowed to have a second job. So having a second job may justify just cause if that second job or performing the duties for that second job harms the employer's interest. And we have an interesting case here, Patterson versus Bank of Nova Scotia. So the customer service supervisor moonlights as a real estate agent. The employer had a clear policy, offered the employee an alternate position in a way to address the perceived conflict of interest. The employee refused, continued working as a real estate agent on the top of being the customer service supervisor at the bank. So the employee was discharged. And that just cause dismissal was considered by the court to be valid. So that's an interesting example of when a conflict of interest would justify just cause dismissal. Disobedience. So a single act should usually be dealt with through progressive disciplining. However, if there's a single act of disobedience that is deliberate, that involves no misunderstanding by the employee and causes substantial harm to the employer, then this could justify just cause. If it is a pattern of disobedience, several events after a progressive disciplining, so remember, the employer should give several warnings to the extent that it gives a final warning telling the employee that if they keep on being disobedient as they have been, they will be fired for just cause. So make sure as an employer you apply progressive disciplining in such circumstances. The case here is Chaba versus Ensign Drilling. So here the employer told Chaba to remove the a buildup of ice from a machine with a pickaxe and crowbar. Chaba tried for 30 minutes but was unsuccessful. So Chaba decided to use a forklift instead. But Chaba was not authorized to drive such machinery. So Chaba caused $750 worth of damage to the forklift and was fired. The court understood here that the misconduct was not sufficiently serious for just cause dismissal. So here, yes, the employer could dismiss the employee, but they should have given reasonable notice or paying leave notice. So that's an interesting example that in principle we could disagree with the court, but considering the damage, 750 and no harm to anyone, no injury to anyone else. So this could not justify just cause dismissal. The employer should have applied progressive disciplining to the employee. Absenteeism and lateness. So we discussed this a little bit already. We know that culpable absenteeism will be a blameworthy absence. So for an employer to rely on culpable absenteeism as a just cause and after a progressive disciplining process, the employer, first of all, should consistently enforce their attendance policy, and they should also impose the progressive disciplining for absence and lateness whenever they are culpable. And whether they decide to dismiss the employee for just cause or not, they should take into consideration the length of service of the employee to the company, how frequent the employee has been absent or late, whether the employee began to arrive late or being absent suddenly, or if it has been chronic, what the reasons are, the reasons given by the employee are. Again, the employee may have reasonable reasons here. They may be suffering or going through difficult situation in their private lives. Whether that absence or lateness harms the employer, and whether the attendance policy has been consistently enforced to avoid condonation and also to allow the employer to rely on those records for just cause. We have innocent absenteeism, and innocent absenteeism will take place when the reasons for the absence are beyond the employee's control. If it results from a disability, then the employer must offer accommodation to the point of undue hardship. And if there's no realistic chance that the employee will return to work on a regular basis, there may be dismissal, but the employer must be aware that disqualifying an employee from a long-term disability plan could also be seen as a breach of the employment contract. So the first consideration here should go towards accommodation as much as it is possible to avoid lawsuits for wrongful dismissal. Sexual harassment. So usually progressive disciplining is appropriate, but there may be serious cases in which dismissal for just cause may be justified. So the case here is the security supervisor tried to kiss young female members, also asked them to sit on his knee, and describe pornographic movies using sexual gestures. The employer investigated allegations. He denied any wrongdoing. And even though he had been working for 20 years, he was fired. So here the court understood that the employer had a fair procedure, investigated the incident thoroughly, and was well documented, gave the employee an opportunity to explain his side. Hence, the just cause dismissal here was considered valid. In Simpson versus Consumers Association of Canada, the executive director engaged in unwelcome sexual conversations with female staff, also engaged or attempted to engage in sexual affairs with secretaries, who later resigned, and at an offsite business function, undressed in front of other employees, climbed into a hot tub, accompanied by a secretary who removed her top. And when the director was dismissed for sexual harassment, he argued the workplace culture tolerated the sexual conduct, that it was consensual, and in any event, it was an offsite and after business hours. That defense was not accepted by the court. So here, again, just cause dismissal for sexual harassment was valid and was legal. Intoxication. Again, progressive disciplining is usually appropriated in case the employee violates a policy that prohibits alcohol or drug use, or even intoxication. And also in case the employee is not suffering from an addiction disability and is not working in a safety sensitive area. So remember that drunkenness or intoxication, drug abuse, substance abuse, they trigger the accommodation duty on the employer. However, if the employer has offered as many opportunities as possible for the employee to recover, to treat themselves, but they do not, then this may justify just cause for dismissal. And while disciplining for intoxication during work hours, some questions the employer should take into consideration. So, did the intoxication harm the business? Not only the business reputation, but also um, did it offer any harm or safety threat for others, for coworkers? How have intoxicated employees been handled in the past? So the key thing here is condonation, whether the employer has condoned such misconduct in the past or not. Does the employee work in a safety sensitive position or area? And if the answer is yes, so the sanction should be stricter or more strict here. Was the employee's performance affected? And is there a company policy or employment contract term that addresses this issue? So those are aspects that the employer must consider while applying progressive discipline for intoxication during work hours. Substance abuse. So an addicted employee for substance abuse cannot be disciplined. They have to be accommodated, again, to the point of undue hardship. Offering accommodation usually involves providing rehabilitation services or allowing time off so that the employee can attend the services. However, if rehabilitation is unsuccessful, then an undue hardship may be reached at some point, and just cause dismissal may become valid at that point. Incompetence. So there are some principles that need to be taken into consideration for incompetence. First is each case must be decided on its facts. So not suspicion, not allegations, but objective facts. There must be serious misconduct or incompetence. It's not mere displeasure. And the onus is on the employer on the balance of probabilities, as we've seen already. The employee's performance must be gauged against an objective standard. If performance is grossly deficient, then warnings and notices, they are not required because of the gross deficiency. And the employer will have to establish the level of performance that they require, and the employee was either trained or told, was aware of in terms of their job duties. That level was communicated to the employee. Instruction and supervision was provided. The employee was incapable of meeting that standard, and that the employee was warned that failure to meet the standard would result in dismissal. And the threshold of incompetence is lower where there are many warnings. So the more warnings you give, the lower the threshold will be. And to determine whether adequate warnings have been given, the employer will have to show that it established a reasonable objective standard of performance, So it is reasonable, again, not perfect, not average, but similar to another person in the same position. So it is a reasonable standard, but that standard has to be objective, not subjective. Then also show or establish that the employee failed to meet this standard. The employee has had several warnings and they failed to meet the standard, and that they were aware their position was in jeopardy, and that the employee was given reasonable period of time to correct the situation. The employer cannot condone the behavior and then later rely on that behavior to discharge the employee. So if there's condonation, the employer cannot rely on that misconduct or that incompetent performance anymore. And condoned behavior is relevant if the employee fails to respond after appropriate warnings. So condonation is always subject to the implied condition that the employee will be of good behavior and will attempt to improve. So employers should be monitoring whether the employees improve and behave at the level they are required after having been given a chance to improve. So those were the main causes, the main grounds for just cause. And there are grounds that cannot constitute just cause. So here is just a briefly mention of legislation that do not allow employees to be dismissed for just cause in case they are claiming or asserting any of their rights. So if an employee is asserting rights under the BC Human Rights Code, they cannot be dismissed for just cause or even penalized. The same applies for rights they assert or claim under the Employment Standards Act, Occupational Health and Safety Regulations, the Workers' Compensation Act, and the Labor Relations Code for unionized workplaces. So employers, they need to hear the employees' claim and cannot penalize. They may address properly, either granting or denying that claim, but in no way can they dismiss employees for just cause or even penalize the employees. So that was chapter 13, dismissal with cause. Thank you. Bye.